This report is on a judge's desk. It contains a score. That score was calculated by a proprietary algorithm. The man at the defendant's table cannot see what it says. He will ask to see how the score was calculated. The court will say no. The Wisconsin Supreme Court will rule that this is constitutional. The United States Supreme Court will decline to hear his appeal. Eric Loomis drove a stolen car. A judge sentenced him using a score produced by a proprietary algorithm. He asked to see how it worked. The answer was, "That's a trade secret." This is not a hypothetical. This is not a pilot program. Algorithms like COMPAS are currently used in sentencing, bail, and parole decisions across multiple U.S. states. By the end of this video, you'll understand what a risk score is, whether one may follow you or someone you know, and exactly how to challenge it. This is the pre-crime score. Recidivism risk assessment is not new. Parole boards have used actuarial tools since the 1920s, trying to answer, who is likely to reoffend if released? What changed in the last 2 decades is that these tools became algorithmic, proprietary, and embedded in the courtroom itself, not just in parole decisions after sentencing, but in the sentencing decision. And the defendant cannot see how the number was calculated. COMPAS, Correctional Offender Management Profiling for Alternative Sanctions, was developed by a company called Northpoint, now operating as Equivant. It generates risk scores based on a questionnaire and criminal history. The questionnaire asks about things like whether you were raised in a 2-parent household, whether your friends have criminal records, whether you have ever been suspended from school. These factors are not direct measures of your behavior. They are proxies, correlates of recidivism in aggregate data. And in the United States, aggregate data about poverty, education, and policing is not race-neutral. In 2016, a nonprofit investigative newsroom decided to find out whether COMPAS was producing racially unequal outcomes, and what exactly a court had said about it. What they found was not simple. It was not a scandal with a villain. It was a structural problem with no clean solution, and a man whose liberty was at stake while the argument played out. In early 2013, Eric Loomis was charged with 5 criminal counts related to a drive-by shooting in La Crosse County, Wisconsin. Loomis denied participating in the shooting. He admitted he had driven the same car involved. Later that evening, he pleaded guilty to 2 lesser charges: attempting to flee a traffic officer and operating a motor vehicle without the owner's consent. As part of the pre-sentencing process, a Wisconsin Department of Corrections officer produced a pre-sentence investigation report. Attached, a COMPAS risk assessment. At sentencing, the judge said, the judge imposed a sentence of 6 years in prison with an additional 5 years of extended supervision. The maximum on the 2 charges was 17.5 years. Loomis filed for post-conviction relief. His argument, using a proprietary, trade secret algorithm at sentencing violates due process because it prevents a defendant from challenging the accuracy or scientific validity of the score. He was asking, how can I contest a number I'm not allowed to see calculated? The Wisconsin Supreme Court heard the case in 2016. The court ruled, the use of COMPAS at sentencing does not violate due process, as long as the score is not the sole factor in the sentencing decision, and as long as the judge follows certain cautions. The court required that future sentencing reports using COMPAS include a written advisement, noting 4 things. First, the proprietary nature of COMPAS means the methodology for how scores are calculated is not disclosed. Second, COMPAS scores are based on group data. They identify high-risk groups, not a particular high-risk individual. Third, some studies have raised questions about whether COMPAS disproportionately classifies minority offenders as higher risk. Fourth, no cross-validation study for a Wisconsin population had been completed. Loomis appealed to the United States Supreme Court. The court declined to hear the case in 2017. There is still no federal ruling on whether algorithmic sentencing violates due process. If you or someone you know has been through the criminal justice system and received a risk assessment score, or been told a score existed, say so in the comments. The patterns matter. In May 2016, 3 months after the Wisconsin Supreme Court heard Loomis, the investigative newsroom ProPublica published a piece called Machine Bias. Journalists Julia Angwin, Jeff Larson, Surya Matu, and Lauren Kirchner had obtained COMPAS scores for more than 10,000 people arrested in Broward County, Florida. They checked what actually happened to those people over the following 2 years, who reoffended and who didn't. What they found: COMPAS correctly predicted recidivism 61% of the time. That means 39% of the time it was wrong. But it was wrong in different ways for black and white defendants. The tool made the opposite error with white defendants. White defendants who went on to reoffend were more likely to be incorrectly labeled as low risk. In short, the algorithm was more likely to predict that an innocent black person would commit a crime, and more likely to predict that a guilty white person would not. North Point, the company behind COMPAS, disputed the ProPublica analysis. Their argument: COMPAS predicts recidivism equally accurately for black and white defendants, about 60% correct for both groups. By that measure, the algorithm is fair. And mathematically, they are correct. The accuracy rate is roughly equal across races. And ProPublica is also correct. The false positive rate, the rate at which innocent people are labeled dangerous, is nearly twice as high for black defendants. Both things are simultaneously mathematically true. Because the underlying rates of arrest and reoffending differ across groups, themselves shaped by where policing is concentrated, no algorithm can equalize both accuracy and error rates at the same time. And here is why. Because black and white defendants in the data have different base rates of recidivism, rates that reflect decades of differential policing and incarceration. It is mathematically impossible to equalize both the accuracy rate and the false positive rate at the same time. No matter how you design the algorithm, you have to choose which kind of fairness to optimize for. And that choice, which group's errors matter more, is not a technical decision. It is a political one. This is the deeper problem that Loomis's case exposed. It is not. The algorithm is biased because the company is malicious. It is. The algorithm reflects historical inequality, and there is no neutral mathematical solution to that problem. Only political choices about whose error rate to accept. But algorithmic risk scoring doesn't start at sentencing. In Chicago, the police department operated what they called the Strategic Subjects List, sometimes called the HEAT List, a secret algorithm that scored civilians on their likelihood of being involved in gun violence, either as victim or perpetrator. The scores were used to determine who received police attention, community outreach, and, in some cases, who got watched. The list had nearly 400,000 entries. The people on it were not told they were on it. In Los Angeles, The LAPD used software called PredPol, predictive policing, to forecast where crimes would occur and deploy officers accordingly. The ACLU and community groups documented that the tool concentrated policing in already over-policed neighborhoods, reinforcing existing patterns of surveillance. The LAPD discontinued PredPol in 2020. The logic is the same at every stage. Train the algorithm on historical data. Historical data reflects historical patterns of policing. The algorithm predicts who is dangerous. Police resources concentrate on those people. Those people are arrested more. The arrest data trains the next algorithm. The feedback loop closes, and it closes tighter every cycle. This is shadow structures, where we investigate the systems that shape your life without you ever seeing them. If you want to see the final link in this chain, the algorithm that scores your likelihood of being a future criminal as used in courts across the country, and what happens when that score determines your sentence. Subscribe. I want to ask you something directly. Have you, or has someone you love, ever been through the criminal justice system? If the answer is yes, there may be a risk score attached to that experience. Not as a suspicion, as a documented number, produced by a proprietary system, used in decisions about bail, sentencing, probation, parole. Most people never find out it exists. And if the algorithm was trained on data from communities that were over-policed, communities where poverty, housing instability, and historical disinvestment show up as risk factors, then the number that follows you may say more about your zip code than about you. Now, the full picture. Risk assessment tools are used in sentencing decisions in multiple U.S. states. The National Center for State Courts has documented their use in at least 46 states in some form. Most are proprietary. Most defendants cannot access the methodology. In most states, there is no legal requirement to disclose the algorithm's training data or validation studies. Most of these tools have never been independently audited by any external regulator, and the ones that have were not audited routinely. In 2019, the AI Now Institute documented that the criminal justice system has become one of the largest users of AI decision-making tools in the United States, affecting millions of people annually in decisions about their liberty. The feedback loop connects to everything we've already documented in this series. The shadow profile, assembled by data brokers, includes criminal history. The zip code that triggered algorithmic banking decisions is the same zip code that appears as a risk factor in the sentencing tool. The productivity algorithm that recorded your behavior at work can, in some jurisdictions, be accessed by law enforcement. The systems are not separate. They were never separate. Eric Loomis asked a simple question: how was my score calculated? The answer was, you don't have the right to know. What does that mean for you? It means these tools are in use. The legal protections are thin, but you have more options than Loomis did. Your toolkit. 1. If you are facing sentencing and a risk assessment has been used in your case, you have the right to review the presentence investigation report, which should contain the score. Ask your attorney to identify whether a risk assessment tool was used, which tool, and what score was generated. In Wisconsin and some other states, the court must include the 4-factor advisement from Loomis in any PSI containing a COMPAS score. 2. The ACLU has published a guide to challenging risk assessment tools in sentencing. Core argument: the tool was not validated for your demographic. The score reflects group statistics, not your individual behavior, and the proprietary nature prevents adequate challenge. These arguments have succeeded in reducing sentences in some jurisdictions. 3. Check whether your state has passed restrictions. New Jersey and California have imposed limitations on how risk assessment tools can be used in bail and sentencing decisions. Colorado has required audits of risk tools for racial bias. If your state has not, that is a policy gap that can be addressed through your state legislature. 4. If you believe a risk score contributed to an unjust sentence, the path is through your attorney and the appeals process, arguing that the tool was not properly validated, or that the 4-factor advisement was not provided, or that the score was given undue weight. These challenges are harder in states that have not required advisements, but they are not impossible. 5. Know that the legal landscape is still moving. There is no federal precedent on the constitutionality of algorithmic sentencing. The question Loomis raised has not been resolved. The Loomis decision is a state court ruling. It is not binding on federal courts, and other states can rule differently. Eric Loomis lost his challenge, but his case created the record. And the record is what the next challenge builds on. The algorithm produced a number. The court used it, but the argument against it is still alive. Eric Loomis drove a stolen car. He pleaded guilty to the lesser charges. A judge sentenced him using a number produced by a system he was never allowed to examine. The judge said the number corroborated conclusions already reached. The judge said the sentence would have been the same, regardless. But the number was still there, still attached to his name, still in the court record, still unreviewable. When we investigate algorithms that affect employment, housing, health, finance, we are investigating systems that shape opportunities. When we investigate algorithms that affect sentencing, bail, and parole, we are investigating systems that take liberty. Shadow Structures investigates the systems that shape your life without you ever seeing them. This was the pre-crime score. The pre-crime score followed Eric Loomis into the courtroom. In the next investigation, an algorithm that followed a verdict into the appeals process. A man convicted of a crime. A score that said he was likely to commit another one. A sentence shaped by that prediction. He challenged it. He said, "I have the right to know how this number was calculated." A court agreed with him. Then a higher court reversed that ruling. In the next episode, what happens when the algorithm's verdict outlasts the human one? Loomis asked the question in a courtroom. The next time someone you care about stands there, the same number may be in the file and still be secret. If you've ever been told a score exists that you're not allowed to see, share this. Eric Loomis asked the question. He didn't get an answer. Enough people asking it changes that. The algorithm produced a number. The question is whether that number should have the right to remain a secret.